All rise. Next case 34 is now in session. The Honorable Judge John Putman presiding.
Be seated, please. Thank you. State versus Brandon D. Watkins, CR 2013-183.
Morning, Your Honor.
Good morning. Sir, I'm looking at a police statement here. Have you gone over this document? Yes, sir. Do you feel you understand the matter set out in the police statement?
Yes, sir.
Do you understand the charges against you and the range of possible penalties if you're convicted?
Yes, sir.
Are you pleading guilty to battery in the first degree? By doing so, pardon me, you give up your right to have a trial, you give up your right to an appeal. Do you excuse me a minute. You understand this?
Yes, sir.
Sir, by pleading guilty, you're giving up your right to a trial, you give up your right to an appeal. You understand that? Other than what's in this police statement, have you been promised anything? Have you been threatened in any manner?
No, sir.
Are you pleading guilty because you're in fact guilty?
Yes, sir.
What's the factual basis for this plea?
Your Honor, on July 7th of 2013, in or around Norfolk, Arkansas, the defendant would have engaged in a fight with a young man named Jason McFall. He would have struck that individual with an iron pipe, causing serious physical injury.
Did you do that, sir?
Yes, sir.
At this time, sir, I accept your plea. I'll judge you guilty. You're sentenced to 8 years in the Department of Correction. You'll pay $200 in cost, a $200 fine, a DNA fee of $250, $50,000 in restitution. Is that correct?
That's correct.
$20 booking fee. Pay what you owe at the rate of $100 per month, beginning within 60 days after your release. Remanded to the custody of the sheriff. We'll try to check and see when he can get into.
Your Honor, we're requesting a DOC bond until he can go down. I don't believe that the prosecution is going to object to that.
Okay, I'll consider that. I want to check and see what the waiting period is first, but be in custody of the sheriff until I can check on that. Next case on the docket is 14-263, State versus Gilbert Ballman, battery in the second degree and resisting arrest.
Your Honor, I've reviewed the affidavit. I believe Mr. Ballman's applied to have the public defender's services in this matter.
He has, and I've appointed the public defender.
On his behalf, I will waive reading of the information and enter a plea of not guilty in this matter.
Okay,
Would like to take up the issue of bond.
very well. Go ahead, sir.
It looks like it's currently set according to the affidavit at $25,000. I've known Mr. Ballman for a little while now, and I don't believe that he has any prior felony offenses. He's a longtime resident of the area with several family members, including his mother, who is in the courtroom here today. I believe that a bond of $5,000 would secure his reappearance in this court.
What's the state's position?
Judge, I agree with that in the sense that it certainly would be $5,000 would prompt this defendant to come back to court. I think he's a man of limited means. However, Judge, if you look at the affidavit, this is a violent crime. I'm not sure if they didn't have to tase this young man to get him arrested. I don't have the affidavit.
Yeah, let me look at it here.
Judge, for the court's information, and in speaking with Mr. Ballman's family and with Mr. Ballman in the recent past, he does have some psychiatric issues for which he undergoes a regimen of medications. Alcohol exacerbates that situation, obviously, but there are some issues here beyond a standard person who's more capable mentally of understanding what's happening.
Judge, I think all that's accurate, but as a prosecutor, I'm more concerned with the officer that this man involved in resisted hit and is required to be tased. That was a man that's out of control.
Where will he live at now?
I believe he has his own residence. I believe he receives a benefit from the Social Security Administration.
Does he live by himself?
Yes, Your Honor.
I'll set the bond at $7,500, absolutely no alcohol.
Thank you, Your Honor. I'll explain that to him. This might be a situation where the defense will need to file for an evaluation. I will speak with my client and we'll determine that, Judge.
Okay.
Thank you.